All right, I want to welcome everybody to our monthly YouTube Live program, Work Comp Today. It seems like every 4 weeks comes around about every 2 weeks. It really is incredible how quickly it comes back around, but we're so pleased that it's that time for us to get together, for David and me and a colleague, usually from different places in the country. Dave, how are you doing today, bud?
I'm doing well. Glad to join y'all. Things are good.
Well, we're so glad that you have some time, and I always enjoy this hour. And we want to welcome our guest, Barry Hinden from the Los Angeles area. How are you doing today, Barry?
Doing great. Thank you.
Well, we're glad that you've got some time for us. Barry is a fellow practitioner. He is with the law firm of Hinden and Breslavsky. Sorry if I hope I got that.
That's good.
They do similar work that we do, and being a fellow Willig member, we always enjoy their company during this hour. And as you guys who've been watching our show for a couple of years now, this hour is dedicated to the current news impacting employers, employees, and independent contractors. And Dave, we've had a heavy dose of two or three subjects the last almost year now, but I'm hoping that that's going to evolve. It seems like it's transitioning a little bit. What has been some of our bigger topics over the last few months?
Well, certainly the pandemic has been a subject we discuss each month. Gig economy typically rears its head, and then usually we're talking about Amazon. I think those are common themes throughout each of these shows.
It really is. And before we dive into this month's news making articles, Barry, if you would share with us a little bit about your practice and about yourself, and then we'll hop into these articles.
Okay, I've been practicing for 46 years. I founded this firm. We have 17 attorneys. Probably about 85 to 90% of our business is workers' compensation, and the other 15% is personal injury. We
Go ahead, Barry.
We get a fair amount of employment cases that we refer out on a monthly basis, and that's basically it. We have a staff of 70 people in the office. We remained open throughout the whole pandemic, but just socially distanced. We have a fairly large building where we can do that. And we've been very fortunate that our staff, that we've only had, I think, 3 people that contracted the COVID in our office.
Well, Barry, where throughout, or what parts of California does your practice predominantly do you find yourself?
The greater Los Angeles area. Well, we do Riverside, we'll do Orange County, we'll do Ventura, basically from the desert to the ocean, the southern part of California.
Wow. Well, it's Dave. We don't quite have 70 in our practice, but we've had a little bit of a different experience that I want to touch on for just a minute. During the pandemic, we've talked about this quite a bit, that firms have all different parts of the country, depending on your state's laws and the comfortability, if you will, of the individuals in the firm. We've had a kind of a hybrid experience. So I want you to share what we have done just briefly and Barry, we'll ask you the same question about how your firm has been able to continue to practice and to serve your clients.
Sure. So we were kind of built for this. We were ready for it in the sense that we were able to work remotely, and our assistants were already doing remote work. They had just scheduled days to work at home, and we saw no slippage in their productivity. So when the pandemic came and we needed to keep our distance, it just worked out seamlessly for us. Our lawyers continued to come into the office each day, and we just shut our doors and kept our distance and kept our clients out of the office and kind of shifted to virtual Zoom and other programs that allowed us to continue to be productive and meet our clients' needs while protecting ourselves, protecting our families and clients. And so and we've continued a lot of those things even today.
Barry, what about your firm? How have you all been able to? I know the California laws and the Alabama laws have not been copacetic. They've been quite different, but you've been able to continually practice. Have you all done a hybrid approach or just at home, or what's happened over the last year?
Well, last March, a year ago, March, when everything seemed to blow up, we furloughed or laid off 23 people in our office.
Wow.
And some of it was voluntary on their part, that they just didn't want to come to the office or work. A couple of them were because of age. They were concerned about things like this. A couple of them just ready to retire after they had been with us for a long time. We have a number of our staff that have been with us over 30 years. So it's a big family here. And what we did in the office is, because we have 18,000 square feet here, we were able to socially distance. We moved some desks around. We got the shields for each one of the intake secretaries and the receptionist. And just wherever you went, you found all these solutions to sanitize. Mm-hmm. So we had a mandatory mask policy. We also have a thermometer at each one of our entrances for our staff, and also for any potential clients that come in. And we also marketed COVID. We actually advertised for COVID cases, and we got a fair amount of COVID cases. And we've been very successful in proving up those cases as industrial.
Wow, well, that's certainly a contrast to what we've been able to do here. But let's put that on pause for now, and let's hop into these articles. And as we have many different months in the past, the gig economy is one of the articles that kind of leads us off today. And the title is "Gig Work Could Change Under Labor Secretary. Here's How." Now, the article came out a little over a month ago, but it's a continual conversation. And Barry, in your state, the cases and what's going on in your state have really kind of led the country in this area. But what do you see happening in California, which may, I guess, pave the way, if you will, nationally? What's going on from that standpoint about gig economy workers?
Well, last November, we had a proposition that was placed on the ballot, Proposition 22, and both Uber and Lyft put a substantial amount of dollars in to have it passed. And it was passed by almost 59% of the voters in California. And what it did is it classified the gig workers, Uber drivers and Lyft and the DoorDash deliveries, all as independent contractors. A lot of times they called them independent contractors before, and when we had a potential workers' compensation case, we would file it with the Workers' Comp Appeals Board. And even though they were denied, ironically, probably 90% of the cases that we handled, when it came to going to trial, they settled the case. They did not want to make law. Mm-hmm. And this was prior to the Prop 22 passing. But now that it passed, the people have spoken. And but what now we're seeing is the prices of the Uber and Lyft driving have gone up substantially. I just had yesterday somebody that lives near my house. Normally was $27 to go to the airport, and it was $85 to $90 to go to the airport. And yesterday we had a potential client that needed a lift into our office, and so we sent a lift to pick him up, and it came out. It was $17. Where he lives, it would have been normally $5 to $7 to come into our office.
Barry, what do you attribute the increased prices?
Well, I'm sure part of it is the pandemic, because that the whole gig economy has taken a hit. maybe not so much with the DoorDash because there's more
Yeah.
people getting food delivered,
Yeah.
and stuff like that. But as far as the Uber and Lyft drivers, and even the taxi drivers, I mean, we don't see taxis around this office anymore.
Mhm.
And what we've done is we've jumped into it. We've actually bought advertisement. We have 10 Uber Lyft cars with a picture of our 7 partners on the side of the car, and they're driving all around town. So we basically have moving billboards.
Wow.
Sort of interesting.
Dave, you've taken Uber or Lyft recently in our part of the country. Have you seen increased in prices as well?
Yeah, it was a slight uptick, no doubt about it. Barry made a great point earlier. You know, who's getting that extra money? Is it going to the driver? Is it going to the company? I don't know.
I suspect the company wouldn't do it if they weren't going to benefit from it.
Oh yeah.
Well, what do we think if we got a sense of what's going on with Secretary Walsh, excuse me, and do we think that this is going to evolve into giving more benefits to those who are driving, who traditionally have not had those benefits?
We were getting the benefits for them. Now, as independent contractors, they don't have those benefits at all.
Right. Well, I know that, for example, if somebody came to our office, Dave, and they drove traditionally, if they've been a Lyft driver and they get hurt on the job,
Yeah.
what happens? How does Alabama treat them in these types of situations?
Yeah, these gig economy workers, people that drive for Uber and DoorDash, they don't have the benefit of workers' compensation insurance. They don't have unemployment compensation insurance. They don't have health insurance provided through their employer. So there's a lot of benefits that the gig economy worker does not have as an independent contractor. And you hope that the Biden administration is going to be more worker friendly than the Trump administration. You just have to assume with Secretary Walsh, former union leader, is going to be pushing for more benefits for workers.
Well, I know that this is going to be, oh, there we go. That's awesome. I know this is going to be an ongoing conversation. We'll check back. I suspect this fall, Dave, we're still going to be talking about this issue.
Yeah.
We may have to bring Barry back on to talk about this one issue. But let's move on, guys. Let's move to the Texas situation. This is one that's been an ongoing case because we know about what's going on in Minnesota, where over 900 individuals, I think at either 1 or 2 plants, contracted COVID, and whether or not they're going to be able to say that this falls under work comp for their state remains. But they did get some hope here. Dave, what did you see out of Texas in this one article that we got?
Yeah, so, interestingly, there were, 900 meat processing workers all filed for work comp, and they were all denied. So clearly there was a rule in place that all COVID claims were going to be denied. What we're looking at here was that in Minnesota, certain workers did have a presumption that if they contracted COVID, that it was going to be work-related, healthcare workers, frontline workers. But going back to Texas, this was a meat packing worker. And I think we've talked previously about some Colorado meat workers and some Midwest meat workers where there was COVID throughout the plant. But here in Texas, one individual's claim was found to be compensable, meaning that he contracted COVID at work, and as a result, he was entitled to workers' compensation benefits. So that's a great sign, and maybe the tide is turning in the favor of workers who contracted COVID at work.
Barry, what did you glean from this, and how would California treat this, or have you guys dealt with this with the meat packing industry and COVID cases?
Well, we would pursue it as a work-related injury, and in California, the insurance company have 90 days to either accept or deny a claim. Routinely, these types of claims will be denied. Now, you also have to realize that in California, when COVID first hit, our governor, executive order put a presumption in for frontline workers, essential workers, that if they contract COVID, it's going to be presumed to be industrial. Okay, it wouldn't necessarily be for the meatpacking workers, but as a result of that, we were able to build on that, and at least it opened the door and opened the eyes of some of the insurance companies that they better start considering this. And what we're seeing now is we're seeing the long haulers, the ones that have gotten COVID, that are now and recovered from it, but now 6-8 months later, they're still having all kinds of residual problems. So we took a position that if we were going to settle a COVID cases, we would only settle it by a stipulated award with the medical left open. We would not do a compromise and release, which would totally settle the claim. Yeah. And that was our advice to all of our clients. And a fair amount of them, we have filed petitions to reopen for new and further disability.
Wow. Dave, we have a ton of meatpacking and poultry and similar industry in Alabama. I know the answer, but I want you to tell Barry, how would Alabama treat this type of a case?
Yeah, unlike so many other states, there is no presumption in place in Alabama, no rule, no law, no executive order that says that if you contract COVID at work, that it's presumed to be compensable or a work comp or occupational disease. So even if you're a frontline worker, a healthcare worker, a first responder, there is no presumption that you contracted COVID at work. And so every claim for COVID has to be proven very legal and medical causation.
Yeah, we are a much tougher situation for our folks who get hurt. And guys, before we head into the next article, I want to welcome anybody who's watching this live or may watch us on replay. This is our monthly YouTube live show, Work Comp Today. Dave and I and a colleague, today is Barry Hinden out of Los Angeles area. We go through the current articles and news of the month that impact employers, employees, and independent contractors. And as we do each month, we hit the highlights of the articles, and then we do a little comparison between our state laws or policies, procedures with our guests. And that'll be in California. We'll do that toward the end of the show. Guys, I want to transition to our third article, and it says, it's entitled, "Can I get paid for my pain and suffering in my workers' compensation claim?" And Dave, you can just quickly answer that in one word, and then we'll go to Barry because I suspect he's got a better answer than we do. At least I hope he does.
My one word answer is no.
And it never will be, because we are such a employer-friendly state. We are an at-will employment state. The Business Council of Alabama has been a very strong lobbying group for many, many years. Our laws, Barry, in case you don't know, and I hope you're sitting down for this, have not changed since 1987. They were codified in 1992, and that was considered to be the updated version. Our pay rates haven't changed in 30 years. We could go on and on and on, but I don't want it for David or me to end up crying about how bad it is here. But let's ask you, Barry, in California, can you get paid for pain and suffering in a work comp claim?
I have the same short answer, no. But I'll give you a but though. If you have a case where it's a stipulated ward and medical is left open, and you have a situation where you can go back for new and further disability because the person now has this radiating pain throughout their body, or developed fibromyalgia, or all kinds of other things that could be as a result of compensable consequence, we can go after that. So yes, they cannot get actual dollars for the pain and suffering, but they may have a disability that was a 16 or 17% disability initially that may wind up now a 40 or 50%. So yes, they will get paid for that increase in their disability.
It's a good point that you just raised. Dave, talk about how a body as a whole injury can evolve from a scheduled member injury if that pain factor becomes so debilitating. That's the one caveat that we do have. And I'm glad you brought that up, Barry.
Yeah, sure. So scheduled injuries are injuries for specific body parts like a leg, an arm, an eye, a finger, a toe. Not scheduled are body parts such as the hip, back, and neck, just to name a few. So if you have an injury to your leg, but you develop debilitating pain such as RSD, then that would make take the injury out of the schedule and make it a body as a whole. Injuries to an arm, if you have an injury to your arm and then you develop depression or a mental injury, then that would take that injury to the arm outside the schedule and it would become a body as a whole. And generally meaning it could be worth more to the injured worker.
But the pain, the impact can't just be of average, oh, it hurts today, I can't go outside to get the mail. It has to be so debilitating that you basically don't function.
Yeah.
And it's a very high standard.
It's chronic pain. It's pain that is intense pain over a long period of time.
So that's something, Barry, that we look for in all of our cases, because it is body as a whole cases allow for higher compensation overall than just the scheduled member injuries.
Now, the schedule you talk about, is that the AMA guides?
No, that'd be the Alabama. Well, yes and no. You take those guides, the PPI ratings that are in that are given out, and it can be part of the factor. But we have a schedule in Alabama. A finger is worth X number of weeks. A hand is worth X number of weeks, and that's how we do our calculations. But it is capped at a certain number of weeks for each of those specific body parts. I mean, there's literally a chart that we have of the human body that we sometimes show our clients, and we could spend the whole day on this alone. It's been an area of contention for our side of the bar for many, many years to get all of this raised. We're not there right now, and anyway, we probably ought to pause that topic because that truly would take up our whole day on it. But guys, there's some research in this next article that I think even Alabama at some point or another is going to come around to help out. And it says, legalizing marijuana leads to fewer worker comp claims. A Temple University research finds. Now, Dave, we just had some new law put into place that impacted medical marijuana. What do you think about this article, and where do you think we're going in our state?
Yeah, so we've got more and more states nationally that have passed medical marijuana and recreational marijuana. The thing that stood out to me was this, and from this study, that following a state's legalization of recreational marijuana, there's about a 20% reduction in the probability that a person reports having any income from work comp. So in other words, legalizing marijuana can lead to fewer work comp claims in a particular state.
Now, Barry, your state's laws are way different than ours and have been for many years in this area. I guess I want to ask it this way of you. What's the impact of either medical marijuana or the findings of recreational marijuana in an injured worker's system after I presume that they're drug tested after injuries?
But now California has legalized both medical and recreational. Okay. To support what David said, we can see that when people are using marijuana to help offset some of the pain and suffering that they're experiencing, it can be and probably will be reflected in some of the reports of either agreed medical evaluators or qualified medical evaluators, the so-called neutral doctors that are making a determination as to what the person's ultimate disability is. And I think that it could have a substantial effect on it. If you walk into a doctor's office and all of a sudden this guy's low back problems with the radicular pain going into his lower extremities is been minimalized as far as because instead of him taking Advil and Norco and some of the other drugs that are pretty heavy and very addictive, they're taking the recreational or medical marijuana, and it's helping them.
And I think there's lots of studies, including this one, that back that up. Now, Dave, unfortunately, one of the areas that Alabama does lead the country in is the per capita abuse of opioids. And we have certain pockets of our state, Barry, that dwarf other areas of the country, sadly, in abuse of illegal narcotics, particularly opioids. And Dave, it seems like we're finally, some of the decision makers on this issue are finally recognizing that, because just the sheer either loss of life or the sheer volume of costs from a healthcare standpoint that it stresses our state. Do you think we're going to come around and really do some things that help out our injured workers on this issue?
At one point recently, we had one county in Alabama, Barry, that led the world in number of opioid prescriptions per person in the world, about 45 minutes north of us. Obviously, we've seen what this opioid epidemic has done. And so these doctors are going to have to find other ways to treat people's chronic pain. Marijuana is certainly one of those alternatives, although not legal in Alabama fully. And I also want a side note. I read this week that Los Angeles Laker, is it Alex Caruso? Is Alex Caruso that he was arrested in Texas? So legal in Los Angeles, right, in California, to have marijuana, but was in Texas and was arrested for possession of marijuana. So not that was in the middle, not that I had anything to do with work, but just interesting that he was leaving his state that where marijuana was legal and then went to Texas where apparently it's not, and was arrested for that.
Let's take it one step further, though, is that a person that becomes addicted to opioids or even marijuana, it can result as a compensable consequence of a work injury, and therefore increase the disability, the impairment. And so it's a double-edged sword, where marijuana could also result in a reduction in pain. It also could result in a substantial increase in mental problems, PTSD, all kinds of other things as a result of overuse of it.
That is interesting. We're going to come back in a few minutes toward the end of the program about drug screens and the impact on a claim. But I want to pause that for now, guys, and let's move to this knuckleheaded Alabama nurse and social media. We do tons on social media. That's how we do our marketing. That's how we reach potential clients. We also do a lot of education, whereas we speak in the school systems about the impact, particularly for those who are in that 13 to 17-year-old age range, of what you put out on social media will always be there, no matter if you try to delete it or to get rid of it. And you just wonder, well, they tell you what they're thinking, but you got to wonder, what are they really thinking when an adult Alabama nurse, he decides to get on social media and just tell the whole world everything that he thinks about certain topics that frankly he had no business doing. Dave, pick it up from there and just share just a little bit more about what this guy did and the impact on his employment.
Well, this idiot decided to get on TikTok and say a lot of stupid things, spreading misinformation, saying racist, homophobic things, which he's got the right to do. He's got the right to do it. But what he's now learned is that there are sometimes consequences for saying these things. And as a result, he lost his job working for an Alabama hospital. So it's just another example of say whatever you want to say, but there are consequences for saying things that reflect poorly on your employer, and he lost his job as a result.
But Dave, what about free speech? What about doing this on your own time and you're at your own house, or you're not at the employment, you're not wearing the garb, or your name tag says nothing about where you work?
Well, unfortunately, he was wearing his name badge at times. His name badge was legible in some of the pictures. And even if it wasn't, again, you're right. He can say whatever he wants to say. He's got the freedom to do that, but he doesn't have freedom of consequence. And that's what happened here.
In light of the recent Supreme Court decision, with only one dissenting vote on the cheerleader who basically was kicked off the squad and didn't make the squad or whatever it was as a result of some of the profanity she used on social media. Supreme Court just came back and said that's her free speech. And so we'll have to see what happens as far as, with these employment situations, whether that's going to be taken up any further.
Yeah, I wonder if we're going to see this case continue up the ladder in the courts because of what you just said about this recent case. But I'm wondering if there's a difference in the way that this cheerleader presented her social media versus what this guy did. And I don't know, there's so many similarities in the two situations, but many, many differences. I know that, again, with Alabama being an at-will employment state, we don't have a lot of protections for our workers in these regards. Would California have any more protections for this situation if it went on in your state, Barry?
We're an at-will employment state too. But I think it'd be very interesting in light of this decision, whether the employment lawyers would be interested in a wrongful termination case based upon someone's free speech. Mm-hmm. Now, if he was making derogatory remarks about where he worked, mm-hmm. and that might be a different situation. But if it's just general, just ranting and raving, who knows what would happen.
I think when it comes to employment, I think one of his problems is this. He's wearing nurse scrubs in some of the videos. In other videos, he's actually recording inside of a hospital room with his badge on, flashes his name, where he worked, and it names the employer. So I think those are some problems he has created for himself when it comes to his employment. More, I guess on the flip side, if you take away all that, if he's not doing it at work, if you don't know where he works, if you don't know if he's not wearing his name badge, it's interesting how the facts change, or how that would impact the decision there by removing the employment aspects.
Well, we're going to monitor this one because I suspect it may circle back around sometime in the next 60, 90 days if some employment lawyer in our state or nearby may want to pick this one up. But guys, let's move in to our last article. And we've actually dealt with this type of situation in the past. Widow entitled to wage benefits in husband's suicide. And this one comes out of the state of, is it Pennsylvania, I believe? Barry, have you dealt with this type of a case in California? I found this to be a fascinating article.
Well, we do have death benefits in workers' compensation. And as it indicates in this article, includes the burial expenses, survivor benefits. We have to establish dependency. In California, if the person's married and the spouse is earning less than $30,000 a year, he or she are classified as total dependents. Okay, minors are also classified as total dependents. And if you have a minor or another child that has some type of disability, it could be a lifetime benefit for those people. So Yeah,
Well, let's presume that for whether it's in Alabama or California, we have the dependency. We have that. What I want to talk about is the causal link between his physical injury and the depression, which led to, in theory, his suicide. Dave, if we have this case at home in Alabama, what do we need from an opinion, from an expert's standpoint, to be able to show a judge or ultimately convince in a settlement that we've got what we need to be able to prove that there?
I think first you're going to have a physical injury, because in Alabama there is no such thing as a mental injury. You have to have a physical injury in order for a mental injury to then be compensable or work related. And in order for the mental injury to be related to the physical, the mental injury just has to be a proximate cause of or come from the physical. So if this is in Alabama, as long as the doctor says that mental injury arose or is a proximate cause of the physical injury, I think this is a compensable claim, and death benefits would have to be paid on this type of case in Alabama.
Barry,
what do you think?
Barry, in California, can you have a mental injury that's compensable, or do you have to have physical that accompanies the mental?
oh, you can have mental too. And we have a California Supreme Court case right on this point. It's called South Coast Framing versus the Workers' Compensation Appeals Board. It's a 2015 opinion. And they indicated in there, all that is required is that the employment be one of the contributing causes. Without the injury would not have occurred. So if this is a death claim, we don't have to show proximate cause. All we have to do is show it contributed to it. Mm-hmm. So it's actually a much more liberal interpretation. And I think if you have a death as a result of a work-related injury, and we could show that it's a contributing cause, we got a compensable death claim.
Yeah, it's a sad situation for the widow and the family, and I'm glad that they were able to secure benefits in this situation. Well, guys, that'll conclude our articles for this month. But before we get out of here several minutes from now, I want to take a little bit of comparison, because our state's laws on work comp and many other things, of course, are so drastically different between California and Alabama. I want to, in the work comp context, I want to just talk a little bit of comparison about how we handle things here, Barry, versus how California would handle them. Dave, I'm going to let you kick off. We're going to talk about a situation where somebody gets hurt on the job and they test positive for marijuana. And what impact would a positive test have on an injured worker's claim?
Okay. So the burden of a positive drug test is going to be on the employer to show that positive test that should be a bar to recovery for work comp benefits. And even if there's a positive test, then the injured worker still will receive medical treatment on the injured body parts. They are just, they can deny compensation for the injury, both temporary benefits and permanent disability benefits, if there's a positive drug screen, unless the judge finds that the impairment did not or was not the reason for the work accident.
Well, Dave, yeah, I was going to say, what if you have a situation where a fella was changing his shoes, getting out of his work boots into his go home shoes, if you will, but he was in a designated area where he was supposed to be and could be. But then we had ductwork that fell from the roof, the rafters, and landed on him and created a horrible injury to his neck and his back. But after the event, he tests positive for pot. In that situation, he didn't do anything to create the accident and the event. He just happened to be in harm's way. Would you grant benefits in that situation?
I think benefits be granted because him sitting there in a spot that it's okay to sit in, and he wasn't doing anything wrong, and having marijuana in his system didn't create. There was no impairment that caused that accident. He was just wrong place, wrong time. I think the employer is going to have a hard time proving that the impairment was the reason that he was injured on the job. So I think
even assuming he was impaired, it could just be in the system, but not be of certain level.
That's
Barry,
right.
let's take it out to California. How would your state treat that kind of a scenario?
I think he would be compensated. I don't see any problem in winning that case. It's going to be a medical issue, and the doctors are going to have to make that determination, and it's going to be very hard for a doctor to make a determination without knowing the exact state of mind and how much the marijuana would influence his body and decisions and reactions and all that stuff. But if the guy is just sitting there, pretty much at his desk, changing his shoes, and all of a sudden something falls down from the inside of the building, I think that'd be a clear compensable case.
I think a much more difficult fact scenario is if you have a guy driving, or if you have somebody who's in a vehicle and maybe he's parked and it gets into an accident. I think that's a much tougher type of a case.
Driving, or if someone falls off of something, or if there's a balance issue, those are the harder cases to prove.
That's the judgment, whether it's an impairment or not situation. But you're right, Barry, they're all fact specific when it comes to this issue. Barry, do you guys have what we call case nurses or case nurse managers in cases in California?
Yes, we don't have those in most of our cases. It'd have to be a fairly serious injury for them to get a nurse case manager. And the way a lot of applicants' attorneys look at the nurse case manager, especially since they're brought on by the insurance company, the defense, is that they're spies. They want to go to the doctors. They want to be in the room with the discussion. They want to be, and a lot of that is really they don't have the right to be there for that.
Barry, some of those case nurses are fantastic. I want to preface it. But David, how do we deal with these wolves in sheep's clothing?
Yeah. So Barry, interestingly, in Alabama, case nurses are involved in most of our cases, and it's because it's a cost containment issue.
Sure.
For catastrophic injuries, Barry, I will typically allow the case nurse to have communication with my client, just because there's so much treatment, and I know most of those case nurses, and they're going to do a good job. For the run of the mill, less catastrophic type injury, my clients tell the case nurse that they are not allowed to be in the examination room with the doctor. We can't stop the case nurse from speaking with the doctor, from speaking to the doctor's nurse, but that's our client's private time with the doctor, and the case nurse is to wait outside in the hall while our client is being examined by his or her doctor.
We've seen a substantial change in the philosophies of the insurance companies on case nurse managers ever since Governor Schwarzenegger established the medical provider networks for these MPNs, they call them. Each insurance company can establish their own medical provider network, and they could insist and require that the injured worker treat within their own network. So basically, they're treating with a doctor that is sort of defense-minded to begin with, and is being paid by the defense. And then we have what they call utilization review, when their own doctors do what they call a request for authorization. Every 45 days, there has to be some type of whether PR2 or progress report. And combined in the progress report is a request for authorization if the doctor wants to send them to another doctor, or to request additional treatment, whether it be medication or physical therapy. And the insurance company then in-house has a UR department, and there's a doctor that works for them in their house that basically has 5 to 14 days to either accept or deny or modify what their own doctor is coming up with. And in 2016, California legislature passed a bill, assembly bill, because they apparently discovered that some of these doctors that are working in-house for the insurance company were getting paid commissions by their own insurance company for the amount of money that they were saving the insurance company by denying utilization review requests.
Yeah.
Requests for authorizations. And virtually our insurance commissioner did virtually nothing. I actually had a meeting with somebody who was running for attorney general in California that ultimately became attorney general in California on this issue. He came into my office and we spoke for 45 minutes, and he said, this was really, and I showed him the assembly bill. I said, why would the assembly pass this unless they had information and evidence that this was going on, that basically there was kickbacks going on? And he said, send me a letter, put all the points in there, and I'll give it to our attorneys to investigate this. Never heard back from them again.
Yeah, it's like in Alabama, sometimes the work comp world that we live in doesn't rise to the level of importance to those who are making the ultimate decisions on our laws. And guys, we've got one more quick topic of a comparison before we get out of here for the month. Lifetime medical care. Barry, do you have that in your work comp cases in the settlements or resolutions to cases?
Depends how you're defining lifetime medical care. If it's as a result of the injury and to cure or relieve the effects of the injury, the answer is yes. But if it's other body parts that were not involved in the injury and were not considered compensable consequences of the injury, the answer is no.
Dave, that's one of the things that I'm glad we still have as a right in most settlements and or trials, is that we can get lifetime medical care, Barry, again, for those injuries that are impacted from the accident or the exposure, whatever it may be. Not for all body parts, but just for what's impacted in the claim.
Well, that we have that too. As long as there are compensable consequence of that. And we're seeing in psych now a lot of the issues of PTSD, and because a person is not fully recovered and now is having all kinds of other problems as a result of it, psychological, medical, mental, all kinds of other problems. So, and now, as we talked about before, the long haulers with the COVID cases, if that becomes work related, there's potential exposure. I did a seminar a number of years ago, and actually I've redone it for California Applicants Attorneys Association and also for Willig. And the issue was it's called Sleeping Giants. Oh, and I just pulled it out and I actually have it here. It's identifying those sleeping giants. And what is a sleeping giant? Is it how many of us have stipulated awards sitting in our garage in a file cabinet that we haven't addressed in maybe 5, 6, 10 years because the case is over, but it may be open for future medical care. And I had a situation, one of the ones that I brought up, I had a 15% stipulated award. Okay. I went back and spoke to this client. In our office, I would say probably once every 6 months to a year, when a case is open for future medical care, we'll send a letter. First of all, it's good PR for your clients, for the firm. And it's great, a marketing tool, and letting the clients know, are you treating? They're not treating within the workers' compensation system anymore. In many cases, their spouse may have medical coverage and they're going to a doctor on that, or they have a subsequent employment and they have medical coverage there and they're going to doctors for that, and this case that I had this 15-16% stipulated award, which was probably what $12,000-$14,000 at the time, We settled 5 years later for $615,000.
Wow.
And I said, don't forget these sleeping giants. Look at to revisit all these cases that you've settled years ago where the sleeping. You're not reopening them. But just if they still have medical care and they need it, you bring it to the insurance company's attention. And when we start notifying people like Blue Shield or Blue Cross or Kaiser, that's treating them now, that hey, there's a work-related injury with medical left open. This is the name of the insurance company. Here's the last adjuster that was on this case. Here's the claim number. It's amazing how they'll send letters to the insurance company saying, hey, we've been treating this person for the last 4 years and you guys haven't paid us for it, and we want to be reimbursed. Mm-hmm. It's amazing how many of those insurance companies on the original comp case are coming back to us and saying, let's close this. What do we need to close this case?
Barry, that's the biggest fight we have in our cases in Alabama. It's over medical care. It absolutely is.
Sure.
Barry, thank you so much for spending this almost hour with us on our monthly work comp today. We really enjoyed your insight and experiences that you shared with us.
I'd love to send you this article if you want.
Absolutely. Absolutely.
Okay, I got a couple that I'll forward to you.
Thank you. And guys, we want to thank everybody who's tuned in with us live or that may watch us on the replay. As Dave and I and a guest each month do, usually the third or fourth Thursday of each month, we get together for Work Comp Today. Dave, what's the new name that we're still thinking about changing it to?
Work Comp Nerds.
That's what we do best. But guys, we talk about current newsworthy information that we find each month that impact employers, employees, and independent contractors. We want to thank our guest, Barry Hinden, out of the Los Angeles area, a fellow Willig member. And we will see you guys again in about 3 or 4 weeks. We hope you're safe and continuing to have a good summer. You guys take care.